And we're live, and good morning, and a lovely morning it is. And fresh from a triumph in the courts is our resident judge, well, not yet, Richard Barton. Good morning, Richard.
Morning, Keith. Yeah, I'm sorry. I've been neglecting you for the last week or so because as you say, I was involved in prosecuting a really rather nasty case. Um, but I'm glad to say that the person I was prosecuting is now one of our neighbours, living in the big building between where I live and you live.
Ah, right.
So that's
The fortress-like building.
the fortress-like building. Yes, it's not easy to get into, and even more difficult to get out of. Yes.
I wonder, Richard, whether you know that great fuss is made of the Russian prisoners who were in the old prison,
Yes.
the old naval prison, but there were also Russian prisoners or Finnish Russian prisoners they were the first denizens of this jail when it was built in 1850 something.
I didn't know that. No, I didn't know that. I know that. I know
Well,
that.
I didn't either until I got them confused one day when I was reporting, and suddenly realised that there were two batches.
Yeah. When it was built, HMP Lewis, people were people were very proud of it, and I've got a postcard from the chaplain there, which he sent to somebody. I bought it in a second-hand shop, but it's a picture of Lewis Prison from the outside because it's such a magnificent building that it was worth having a postcard made of it. I don't think we'd have that nowadays. Yeah, I don't think we'd have that nowadays. But yeah, it is an impressive building. It's a very gloomy building.
And of course, the last woman to be hanged in Lewis was hanged, I think, outside of that new prison. The Sarah, I've forgotten her last name, but is it the famous onion pie murderess?
Yes. Not that she murdered onion pies, but she used onion pies to murder people. Yeah, just for the sake of clarity there.
Well, it was an arsenic pie, in fact, wasn't it?
Yeah, I don't think there is an offence of actually even assaulting an onion pie, let alone murdering one. But that's just
anyway. I digress from the important things that you have to tell us. So where you go?
Okay, well, I don't have. I've got a couple of things. I wanted to just start with the usual sort of slight roundup of legal issues. The multi-claimant High Court action against the Daily Mail continues. It doesn't receive very much publicity at the moment, but each of them have been in the witness box, and I think they must be gradually coming to an end of those. And I did see that your hero Paul Dacre, he came and gave evidence, I believe. I don't know if you saw that, Keith.
No, I do have a lot of admiration for the man. Yeah.
Yeah, I know, and as I understand it, his evidence was to the effect, I didn't know any of this was going on. As soon as I heard rumours it was going on, I stamped it out immediately. So that was his position, which may be completely accurate. But it does sound as if there were people lower down the food chain within the organisation who were taking the law into their own hands. Maybe not reporting up the chain, but actually doing whatever they could to get information.
Of course, a big organisation like that it's very difficult to find the line between giving reporters and your editorial staff a certain amount of freedom, so they don't look as it doesn't look as if you're watching them every second of the day, and keeping some sort of control to make sure they're not getting out of kilter.
Yes, there must, I'm sure, have to be a level of trust there, because a reporter seeking to investigate might not even want to share with colleagues exactly what information they've got, because it's their story. I don't know if that's the case, but as an outsider, I can imagine that must be the case from time to time.
Harold Evans was the master of it, of course. Is in the old Sunday Times before Rupert ousted him. Yeah. He had a great team of investigative reporters. Yeah. And I got to know a couple of them, and they would disappear for months on end.
Yes.
And nobody knew what the hell they were doing until they came out with a story.
Yeah. Yes, I remember there occasionally very explosive exposés of things, and they were clearly very well researched. But I think you may have said this before, probably in journalism nowadays, there's such a need to have a quick turnaround. You've got to justify, what have you done this week type thing. That slow burn, which goes with those sorts of investigations, is much more difficult to achieve, I would have thought.
Well, there's also the question of we have a generation of journalists, and I know this because a recently retired senior editor who is related to a friend of mine told us that he didn't know how to stop the younger generation coming in and being used to almost ripping and reading from the internet without checking, which is very dangerous, of course.
Oh, that's enormously dangerous. Yes. I find the same thing. For example, sometimes I'll have reporters who will say, "Oh, can I have a copy of your opening note in a case?" So what I've said about a case. Now, journalists of a certain age know how to approach that, because it's not what I necessarily have said in court. And also sometimes it, for example, contains names that should not be in the public domain. There are some people who have a right to anonymity. But when it's a younger journalist, I do find myself having to remind them of these rules, because they just seem to think, no, that's it. I've got it now. I can go away and type this up, effectively cut and paste what Mr. Barton's given me, and that will do. And it won't.
Yeah. Well, I had to deal with this in Kosovo.
Yeah.
When I went out there in 2000, 2001, 2002 to help get their news operations off the ground after the war.
Yes.
And their new editorial freedom, they thought, gave them the right to say anything without any checking and without any responsibility.
Yes.
So we actually had to sort of coin the phrase, a responsible journalism.
Yes.
No news without checking, sort of thing.
Yes. Yes. Anyway, as I say, that multi-claimant case burbles on, and I would imagine within the next week or so there may be at least a conclusion of the evidence. Now, whether the judge is going to go straight to giving judgment, I tend to doubt, because you've got a number of people making claims, and each one of them making slightly diverse claims, and the judge would want to consider all that and get it right. It's not a case where a judge will give an extemporary might give an indication, but won't give a full judgment at that stage. So we'll have to wait even longer. Another thing I wanted to mention, Keith, is this, and you may have seen this, and it's not something that I have come across before legally. There's a trial going on in Winchester of a man who is charged with manslaughter of his wife. And it's said of him that he was behaving in a controlling and coercive manner. That's an offence in itself. It's a sort of global offence to cover somebody in a domestic situation who is controlling it or coercive. He's also charged with having raped her a couple of times. But she then went, and this is the odd bit. Keith, I'm getting feedback of my voice. I don't know if there's.
No, I'm perfectly okay here.
Okay, right.
Are you getting a feedback?
Yeah, so I can hear myself. With a sort of second delay.
It's not coming out here.
Okay, that's all right then. He's also been charged, this fellow, with manslaughter. And the basis of the manslaughter charge is that she committed suicide. And the prosecution are saying, effectively, he drove her to that. Not suggesting that he actively encouraged her in any way. This isn't sort of assisting a suicide type thing. It's simply that by his controlling coercive behaviour, he drove to the point where she felt life wasn't worth living. She felt she couldn't leave him because she feared what he'd do to her and her family. And so she killed herself. Now, I have never heard of a case like that before. I may be wrong. There may be some examples of it. I haven't researched it, but it seems to me quite a bold leap.
Yeah.
Because if charged with controlling and coercive behaviour and rape, if he's found guilty of those, he'll go to prison for those. There's no question about that. And it would be an aggravating feature of the controlling and coercive behaviour that she felt driven to kill herself. But to actually describe that as manslaughter seems to me a significant leap in the terms of the law. So we'll have to wait and see what happens. Obviously, it's up to the jury. But it was a very bold decision, it seems to me, on the part of the Crown Prosecution Service to charge him in that way.
Perhaps we could explain, Richard, the process of how the Crown Prosecution Service determines what charges will be brought.
Well, they take a coin, they toss it in the... No. So what happens is that in any case of any size, very minor cases, police can make decisions about charging, so driving offences, speeding, that sort of thing. But any case of any size, the police have to put together a file of paperwork and what they've collated. And then they send that to the Crown Prosecution Service. And one of the delays, I regret to say, in the criminal justice system at the moment is that what are called the reviewing lawyers. So these aren't people who go into court. They simply spend their lives sitting, reading the files that have been submitted by the police. And then that person, the reviewing lawyer, decides on what the appropriate charges are. So it's not a police decision. It's if I get briefed in a case, so I'm up on my hind legs in court prosecuting it. It's not my decision either. It's a slightly old system because 35 odd years of doing the job, I sometimes find myself having to phone somebody who wasn't even born when I first started practicing. Who's the reviewing lawyer? And I need their approval for what I think ought to happen. You don't always get it. But those reviewing lawyers do work very hard. It's a very stressful job. They have huge caseloads. So file after file after file. And as a result of that, some of the, dare I say it, the better people end up moving away from that role because it's just too stressful and having such a, and I can imagine if you've got a massive caseload, it's not the cases that you know about that you worry about. It's the others that you didn't think were a problem, but in fact do have some kind of time bomb ready to go off, and you the will be blamed for not doing this, that, and the other. So there are some very good, very excellent reviewing lawyers who work hard. And I hate to say it, but there are some people who are civil servants and have that civil service mentality where they work their hours, and it's impossible to get hold of them outside their working hours. And those of us who prosecute find it frustrating that often we pick up a case and there are things that have not been done properly. And the police, who often are at court, of course, with you, will tell you, well, we're frustrated as well. And I'll say things like, do we not have a statement from X? And the police will say, yes, we submitted it to the CPS 3 weeks ago. And I'll say, well, I've not seen it. It's not been put on the case system that the court has access to, or the defense has access to. And therefore, we might have problems. There's a trial I'm aware of going on at the moment in Sussex, where it involves large-scale importation of cocaine in a lorry, and the evidence isn't great. Save this, that the lorry's tachometer, which shows not only when it's been driven, but it can also ascertain where it's gone, showed some very odd movements on the continent before this lorry came into the country. So the lorry going and meeting a lay-by for half an hour, and then reversing back and going back on its route. That is wholly consistent with the driver going to pick up the drugs. But that was served so late that it wasn't used. So these things can happen to the detriment of the prosecution generally, and also, of course, the difficulty is often in cases where you have victims, and you find that there's been a failure of that kind, having to tell them, look, I'm sorry, this has happened in this way. And why has that happened? Well, I'm sure the reviewing lawyer was very busy, and it all sounds rather feeble as an excuse when you tell them. So that's the process. CPS make the decisions, a reviewing lawyer makes the decision. If the police don't like the decision, they can then appeal that to a more managerial lawyer to say, we think that this chap ought to be charged with 3 offences of killing an onion pie. And in fact, we've only got 1 charge coming back, and we don't think that's right. And so there is a review process within the CPS, but it always remains solely with the CPS, the decisions that are made. And some judges get frustrated with that as well, because a judge will say, Mr. Barton, why are you pursuing this as opposed to that? And I have to say, well, it's not my decision. I will take your view back to the CPS, but the judge has no ability to change the indictment, the charge sheet. I don't. All a judge could do in the case is to stay a case. In other words, to say it is an abuse of process, and so I'm not allowing this prosecution. But that's a very narrow band of cases that fall into that category. And if so for example, if the reviewing lawyer could say, well, our opinions differ, and it just comes down to that, a sort of tactical decision, then there was no way that the case would be taken. So that's the system we have.
It is, to all intents and purposes, what I would call a mistrial. Does that take place very often?
When you say a mistrial, that's a horrible Americanism. Do you mean?
Yes, I know it's an American, but I was going to say that you see it a lot on television. Does it happen frequently in British courts?
Yes, now and again. Well, there are various ways in a mistrial can happen. One of those is that a jury at the end of the case might not be able to reach verdicts. So that means that whole trial becomes a nullity, and then a decision has to be made whether or not to seek a retrial. But I don't think that's really what you're talking about. You're talking about cases being stopped halfway through. And there are various reasons why cases can be stopped halfway through. Sometimes a witness will say something that isn't admissible. And occasionally it's a minor thing, and the judge can just warn the jury and say, you have to ignore that. It's not part of your deliberations. It's not part of the evidence. But if it's something of significance, then that can cause a jury to be discharged, and that whole trial would then be a mistrial. The most typical sort of version of that is the prosecution witness who, despite being warned, gets in the witness box and whilst giving evidence about what the jury have to decide, the witness goes on and says, well, and of course, he's done this before, and this and this, where there hasn't been an application put in his bad character. And that would almost guarantee the jury being discharged. I may have told you, Keith. I don't know. I had a trial before Christmas where I was prosecuting a man for a really ugly assault on a stranger, daytime, just by St. Peter's Church in the middle of Brighton. And the defendant said, well, this chap, and he was an A-level student, the lad, he was walking home. He said he gave me a funny look, and I thought he was going to hit me, so I hit him. And he really did. Give him major injuries. But on day 2 or 3 of the trial, we had a break. And the jury went outside to get a breath of fresh air. And there's this little old woman there who was going around saying, "Can I borrow a cigarette?" And one of the people she asked was a member of the jury. And the woman said, "No, sir, I don't have any cigarettes." And this old woman went round, and then she came back and said, "Are you sure you haven't got any cigarettes?" She said, "No." She said, "I'm just a bit worried," she said, "because my son's here on trial, for up on assaulting somebody." And the thing is, he's done this loads of times before. And, you don't look at him. If you look at him, he'll just punch your lights out. The defendant's mother telling one of our jury what the jury didn't know about the defendant. Now, mercifully, that juror came back into the building, immediately told the court staff, and she was isolated away from the other jury. And she was asked to write down exactly what happened. And we discharged her as a juror. So because of her acting properly, we didn't lose. We only had 11 jurors, but that was enough. But had she gone back into the jury room and told them all, then we would have lost the whole of that jury.
All right.
And so those things can and bless her, this is the defendant's mother giving him possibly the worst testimonial that you can imagine. So those sort of things happen. Sometimes people get ill, of course, and that can cause that there was a very famous murder trial down in Wales, a notorious one, which went on for, I think, quite a few months, multiple defendants. And just as they were getting towards the end of the case, the judge died. And that, as a consequence of that whole process had to be stopped, the jury discharged, and they had to restart. And I know somebody who was in that trial who had spent months down in Wales, lived in Sussex, and then had to go back and do it all over again. Now, going to Wales at once is bad enough, in my experience, but having to go back to it, Swansea in particular, is I consider severe punishment. It's an unnatural thing to do to a person, force them to be in Swansea. So yes, Keith, I don't know if that answers your query.
Yes. Generally, the other question that is raised to a layman is, if you should have a mistrial, who decides?
What? Who decides if it's a that
it's going to be a mistrial? You're going to abandon the case?
It's the judge.
Judge.
Yeah. So and sometimes you do have debates where the barristers will, often as not, if you're defending, it's actually quite useful to have a trial stop and have to be restarted, unless your client's in custody pending that and has no wish to stay there. But witnesses sometimes just say, "Well, I'm not coming back a second time." That sort of thing can happen. The other odd thing about it is that if a judge does do that, what occurs is all the rules about, I think we've spoken about before, custody time limits, how long somebody can be held on remand awaiting their trial. Once that first jury has been sworn, the custody time limit issue falls away. And there is no custody time limit that runs for the retrial. And so the person who is going to be retried, subject to applying for bail, has to stay where they are. This is this happened. I was part of the prosecution team for the murder of Jane Long, which is I think we may have spoken of before, notorious case where her best friend's boyfriend had an interest in necrophilia.
Oh, yes.
Lured around to on the pretext of saying, "Oh yeah, your friend's not here, but come on round, have a cup of tea anyway," and then strangled her to death and kept her body for a while and that sort of thing. What happened with that one is that there was a decision made by the trial judge that it was either murder or nothing. Because, of course, the case that he was putting forward was that this is all part of sex play. And it was an accident. Now, that had the potential to be manslaughter, the middle ground. Judge didn't leave it. He was convicted of murder. Court of Appeal said, yes, that's fine. What was then the House of Lords, now the Supreme Court, said no, and they changed the law and said if there is a middle ground, even if the parties don't want it, the judge has to leave it. But that meant we had to go and have a retrial. But that took quite a long time, and dear old Graham was languishing in prison for all that time because there were no issues about custody time or anything of that. And his other misfortune in that, just out of interest, is that between the first trial and the retrial, the law was changed by an act of Parliament concerning the right to adduce bad character evidence. The old law was that you could only put in something about a defendant if it was strikingly similar to the offence with which the jury are concerned. Much wider now. And I recall up at the Bailey when he appeared by video in Court 1 at the Bailey for a preliminary hearing. And nobody had told him this. And we were discussing it with the judge, well, he's not going anywhere because there's no custody time limit. And of course, we will now seek to adduce all his necrophiliac tendencies, buying access to websites that for men of that persuasion or interest. And it was very odd because normally you don't get to see the defendant behind you. But because he was up on this big screen, big close-up of his face, as these points gradually dawned on him, and he realised how he was up on the screen. It was oddly humorous to see how this confident fellow who thought, well, as I said, retrials, things can change, often better for a defendant. He suddenly realised that in the meantime he wasn't anywhere, and in fact, the second jury were going to hear all about his predilections, and of course, in due course, convicted him. So, again, I don't know to what extent that assists you, Keith, with your question.
If what, sorry?
I don't know to what extent that assists you with your query.
Yeah, sure.
Okay. One thing I did want to mention, because I don't think we've actually talked about this at all, Keith, is the investigation of the former Prince Andrew and Peter Mandelson. I don't think we have discussed that, have we?
Right.
And it had some misreporting, I have to say, where the allegation is misconduct in public office. Undoubtedly, they both were in public office at the time. But the suggestion is made in a lot of the press that in order to be convicted of that, you have to have a financial gain for yourself or for another person. That's not the law. Misconduct in a public office can simply be doing something that you shouldn't be doing, that is thereby damaging to the state. You don't have to be doing it for money. Might well be in this case that there was a financial incentive, I don't know. But it's not a necessary element. But the other interesting aspect of it is this, and we may have spoken about this more generally previously, is that in both of their cases, they were arrested without being given notice. Now, that's always a police decision if they're investigating. But normally in a case of that nature, which I suppose could be put into the general basket of white-collar crime, people with no previous convictions, the police would say to the person or their legal advisors, look, you come into the police station on X date in order to be interviewed. So an interview where they attend by invitation. That would be normal standard practice in this sort of case. But it quite clearly, well, first obviously, Mandelson was a bit easier to understand because the Speaker of the House of Commons thought that he was going to jump the country, heard some news about him going abroad. And that would trigger an arrest. You don't want him, a person, fleeing the jurisdiction to somewhere where we have no extradition treaty, and so they evade justice completely. So I suppose that's sort of understandable. But the interesting one is Andrew. Because the only real reason that they arrested him, as opposed to by him inviting him in for a voluntary interview, is the police had a perception that there was a risk that evidence might be removed in some way. So I don't know upon what they based that, but I don't think the arrest was, we're fearful of him running away. I think it was more that if we put him on notice of this, somebody might well get rid of his electronic equipment that we want to look at, paperwork that we might want to look at, which might go to the issue of whether the police hear it. It's there for that sort of thing to happen.
It seems to me that there was something of a public issue with people being reported as saying, no, he wouldn't have run away, or yes, they were quite right to do that. Now, how much does that sort of public debate affect a decision by either the prosecutor or the police?
It shouldn't at all. Yes, you know, there have been bad examples of the police courting publicity. For example, the awful way that they dealt with Cliff Richard and tipped off reporters what they were doing. So there was a BBC helicopter over his house when they went in to search it. And quite rightly, they got a severe telling off for doing that. Not the reporter's fault. Once they've got the information, they of course they'll use it. But I don't get the feeling that in this case, the Thames Valley Police arrested Andrew simply in order to court publicity for themselves. I think it was more, we want to secure material from both properties without the risk of that material being removed or disposed of in some way. And as we were saying, so what will happen?
If I may say so, it is, you know, particularly say in the case of Andrew.
Yeah.
You've got people who are landed gentry, as it were, titled people expressing an opinion. It must be very, very difficult to come to your own conclusion. I mean, that sort of pressure must be enormous.
I'm sure it is, but this, you know, this is definitely a case where any decision about charging, as we said earlier, police prepare the file, it goes to the Crown Prosecution Service. Any decision about charging is going to go straight to the top of the Crown Prosecution Service, oddly enough, to the Director of Public Prosecutions, a role formerly occupied by our Prime Minister, Keir Starmer. I can't imagine it's just going to be left to an ordinary common or garden reviewing lawyer, put it that way. And of course, an oddity of it is that if he is charged, Andrew, the indictment will effectively read your brother against you, Andrew, because all Crown Court cases, with one or two minor exceptions which involve private prosecution, are brought in the name of the King. So the heading on the indictment would be the King against Andrew Diddly Diddly Doodah, with his name there, which is an odd little feature.
Well, I'm sure that people don't need to be reminded that you are a very eminent counsel. I mean, very eminent. You've got one hell of a track record. How would you feel if you were walking into court and Andrew was to be your first witness, if it were, to be cross-examined?
Oh, well, I'd love to cross-examine him. Of course I would. Yes, you know, I get some feeling that in fact you well, as the interview that he did a number of years ago showed, you don't really need to cross-examine him because he is quite capable of taking his foot and putting it in his mouth on his own. But there will be a lot of, you know, it's a difficult call. Obviously, I don't know what the evidence. None of us know what the evidence is in total. But I just remind you, Keith, that in order to bring a prosecution, there are two limbs to the test that the prosecutor has to apply. Is there sufficient evidence to give a realistic prospect of conviction? Doesn't mean that you will get a conviction, a realistic prospect of conviction. And secondly, is it in the public interest to bring these proceedings. And I can see that this case could be difficult on both of those limbs, frankly. So I'm not 100% sure that we're going to see that trial going ahead. And of course, if it doesn't, then the police and the CPS will need to issue statements giving such explanation as they can of why a decision was made not to prosecute. If he is prosecuted, Andrew, it's going to be the trial of the century, isn't it?
Yeah.
And another difficulty you have with trying somebody like him is that the first question that jurors are asked before they're sworn as a jury, more than 12 people come into the courtroom, from whom 12 will be selected. And it's invariable practice that the prosecutor will be invited to read out a list of names of people who they're going to hear from and locations. And the first name you always read out is the name of the defendant. And the judge will say, so if you know any of these people, let me know. Now, there isn't going to be a person in this country who doesn't know who Andrew is. So there's an interesting question there of how you try him. What we don't have, unlike in America, where they have a system of questionnaires for potential jurors to see their views, their prejudices, that sort of thing. We don't have that in this country. We know nothing about them apart from their name. But I suppose a judge could give them a very stern direction about. Well, as a judge will almost invariably do in cases about not leaping to conclusions, not to trouble about what they've read in the press, only to deal with the case in accordance with their oaths and affirmations, which is to try the defendant on the evidence and not to go beyond that. But I would imagine that would be a very tricky job for a juror. But we shall have to wait and see.
Yeah, indeed. Little thoughts flash across my mind.
That's nice.
As you trigger them with some of the things you say. Am I right in assuming that the House of Lords can actually hold a trial?
Yes, that's an interesting little question. Theoretically, yes. And in the past they did, where you tried by your peers. In the case of a peer, would literally being tried by your peers. But it's not happened for 2 centuries probably, and it's not going to happen nowadays. Simply not going to happen. I don't think public opinion would particularly find that acceptable. So theoretically, yes, but in practice, no.
And when you say that,
yeah,
Richard, I mean, I always remember that famous instance where I was summoned into a trial in Canada to see the prosecutor asked for the death sentence when the moratorium had run out and Parliament had forgotten about it, or the government had forgotten about it.
Oh,
I mean, is there a possibility that there could be a quirk, an oddity, where suddenly everybody would say, "My God, I didn't know that the House of Lords could try"?
Yes, there's a possibility, but in practice, it's simply not going to happen nowadays. I'm confident about that. Keith, I'm sorry to
if
trouble
they tried
you.
it, would somebody nix it?
Sorry?
Would somebody stop it?
Yes.
If it was mooted, would somebody stop it?
Yes, I'm sure. Yes.
Yeah, right.
Keith, I'm sorry, it's coming up for 9, so I've got to go now.
Right. Okay. Well, we've had
We'll have a bit of a
50
chat.
minutes
Yeah.
of very, very good stuff, Richard. I do appreciate it because of technical reasons. You were going to do it last night,
Yeah.
and you offered to do it this morning and get up this morning. And we've had a very good session. I've enjoyed it enormously.
Well, thank you, Keith.
So thank you very much indeed. And I hope that your day in court isn't as traumatic as it has been in the last little while.
Thank you, Keith. You're looking better, if I may say.
Thank you. Well, I must say that sessions like this spur me on to keep going.
Good. All right, I'm going.
Okay.
See you soon.
Toodles. There we are. Richard Barton. This interview will be available later in the day. Not quite sure what time. Probably somewhere towards noon. Thank you for being with us this early. I should tell you that I'm trying to look after my diet a little better than I have because of Parkinson's, and I'm doing all in my power to try and get rid of it. Well, not get rid of it, but contain it. Let's put it this way. So this morning, I did tomatoes on toast. I took the last 2 crusts of bread in the fridge, layered it with cherry tomatoes, and popped it into the oven. Checked. Not much seemed to be happening. Went back to doing a little work, preparing actually for this program. And suddenly there was smoke billowing out of the oven. I did burn the top of a couple of the tomatoes, but generally speaking, I managed to succeed in getting a very decent tomatoes on toast dish for breakfast. I'm now going to go back and see whether, in fact, I'm going to supplement it with some porridge. Porridge, tomatoes on toast. What a way to start the day. What a way. Thought you'd like to know that. See you later in the day, perhaps. At the moment, Mirador is a bit sporadic on the air. Keep checking because you may see something that you like. But we were getting out of date. We're trying hard to being a good and responsible public company. When I say public company, we're not a public company, of course. But what I mean is serving the public and taking it seriously. We're always trying to stay on top of what we do. Make it pertinent, make it useful, and make it fit for purpose. So what you see at the moment, we deem fit for purpose. What you will see after June, well, after the end of May, is back to the regular pattern of 4 days a week, 4 hours a day, with a wide variety of people, some new, some old, but with a different set purpose, and one which we intend to be of use to you, the viewer. So, we say, Toodle Pip, and may the best man win. Right.